How's everybody doing? Great to be learning with you on a Wednesday, Yom Revi'i. Let's light up the darkness. I apologize for being a few minutes late. 10 things happened at the very same time as I was trying to get ready and glitching. But welcome, Chaim in Florida, Aoife in Florida, Alan in New York City. I know there's more comments than that. What's going on? All comments. Load more comments. There we go. Welcome, Melissa in New York, Renee in Indiana, Sharon in New Jersey, Nancy in North Carolina, Guy in Ohio, Belle in Texas, Lucy in Minnesota, Yehuda in South Carolina, Shandora in the Bronx, Bella in Florida, Tom in PA, I imagine. Welcome, everybody. Opening a new tractate, Horayos, the 28th volume of the Talmud. As always, we begin on page 2. Every tractate begins on page 2. There's spiritual teachings about that. You're always in the middle. You're never really at the beginning. You're always cycling through it. But also, it's a bit of a quirk of history that page 1 was understood to be the front plate, and the text would begin on page 2. Tractate Horayos, its first chapter is a short chapter, but the 6 or 7 pages in this chapter are all pretty long dafs, so let's jump in. Page 2, chapter 1 of Tractate Horayos, Mishna number 1. And this whole what this tractate is about is when the court, when the judges, when the Sanhedrin, or when a king, a Nasi, makes a mistake, that a halachic mistake, and issues a ruling of law that causes people, perhaps even the whole nation, to sin. Right? The people are just following the ruling that they received from the judges. The judges made a mistake. They didn't lead the nation astray intentionally. And so an offering is going to be brought. And then so the first question is, well, when do people become liable to bring such offerings? Let's get into it. Some of this material is a bit challenging. Mishnah 1. If a court erroneously issued a ruling permitting the Jewish people to violate one of all the mitzvahs that are stated in the Torah, and an individual proceeded and performed that transgression unwittingly on the basis of the court's ruling, right? He didn't think he was violating the law. He was doing what the court told him to do. Then, whether the judges performed the transgression and he performed it with them, or whether the judges performed the transgression and he performed it after them, or whether the judges did not perform the transgression themselves and he, the individual, performed it alone, in all these cases, the individual is exempt from bringing an offering. He ended up committing a sin according to Torah law, but only because he was following the Torah commandment that you shall do what the judges tell you as they interpret the law. So he's exempt. And this is due to the fact that he associated his action with the ruling of the court. Now, it might be, as we'll see, that the court issued an erroneous ruling, and this guy ended up doing the same action that he would have done if he was following the erroneous ruling, but he was actually doing it for a different reason, like just following his own judgment, or he never even heard about that ruling, and he thought he was committing a sin. Then he was negligent, wasn't careful to avoid committing a sin, but he didn't rely on the court's ruling. Then, even though the court had issued an erroneous ruling, he would be liable to bring an offering himself, a sin offering himself. Remember, sin offerings are for unwitting transgressions. If you do it intentionally, you can make an atonement, but not through a sin offering. And of course, sin offerings are only brought when the temple is standing, which tragically has not in 2,000 years. If the court issued a ruling and one of the judges knew that they erred, despite the fact that the majority ruled against his opinion, or if he was a student and he was qualified to issue halachic rulings, and that judge or student proceeded and performed that transgression on the basis of its ruling, then whether the judges performed the transgression and he performed it with them, or whether the judges performed the transgression, he performed it after them, or whether the judges did not perform the transgression at all themselves and he performed it alone, in all these cases, the judge or the student is liable to bring an offering. Presumably, he should have known better. This is due to the fact that he did not associate his action with the ruling of the court. And this is the principle: one who associates his action with himself is liable, it was his own ruling, and one who associates his action with the ruling of the court is exempt. That's Mishnah 1. Now the Gemara. Shmuel says, the judges of the court are never liable to bring an offering for an erroneous ruling until, right? So these are the elements that need to be met for the judges to be liable to bring an offering. They're not liable to bring an offering for an erroneous ruling until they say to those who are seeking a ruling, it is permitted for you. Rav Dimi from Nehardea takes it even further. He says the judges are not liable unless they say to those who are seeking a ruling, it is permitted for you to perform this action, right? They have specifically said that this thing you're about to do, it's permitted for you to do it, and then he does it, relying on their ruling, and so he's going to be exempt. And then it turns out that since they created basically his sin because of the ruling that they issued, they did it erroneously, and that's why they now become liable to bring the offering of an erroneous court. It is due to the fact that the ruling is not completed if they say only that it is permitted, as perhaps the judges were expressing a theoretical opinion and not issuing a ruling that, hey, you can rely on our ruling to go do such and such. Abaye said, we learn proof for Rav Dimi's opinion in the Mishnah as well. The Mishnah teaches with regard to a rebellious elder, we learned this in Sanhedrin 86b, if the Sanhedrin ruled contrary to the ruling of the elder, and the elder then returned to his city, and nevertheless he taught in the manner that he was teaching previously, so he is exempt from punishment, because he keeps teaching what he taught before. He's not doing the sin, but he's teaching what would be an erroneous ruling. But that's not enough for him to trigger liability. This is not liability to bring an offering. This is liability for a death penalty as a rebellious elder, but not if he just teaches what the law is. It's when he instructs others to act on the basis of his ruling, which contradicts the ruling of the Sanhedrin, then he is liable to be executed. Rabbi Abbas said, we learn proof for Rav Dimi's opinion in a Mishnah as well. The Mishnah teaches, because I'm going to turn on the AC. Okay. As well, the Mishnah teaches in Tractate Yevamos 87b, if the court instructed a woman to marry on the basis of inaccurate testimony, right? So inaccurate testimony would mean that two witnesses came and said that they saw her husband die, so she's a widow, and so she can go and remarry, right? That would be inaccurate testimony. So they said she can go and remarry, but she doesn't remarry. Instead, she proceeded and disgraced herself and engaged in promiscuous intercourse, meaning she slept with somebody without marrying him. So then she is liable to bring an offering, as they permitted her only to marry. And her conduct lacked the approval of the court to go and sleep with someone. So thus, they said that she's no longer married. It's not adultery, it's just promiscuity. But what they said is she can marry, not she can go and sleep with somebody. This indicates that it is not sufficient for the court to issue a general ruling to the woman. Rather, the court issues a ruling that includes instruction to perform a specific action before those judges become liable for the offering of the erroneous ruling. that causes others to act on it. Ravina said, we learned proof for Rav Dimi's opinion in the Mishnah here as well. If a court unwittingly issued a ruling permitting the Jewish people to violate one of all the mitzvahs that are stated in the Torah, and nothing more need be said, and it is clear from the phrase issued a ruling to violate, that the ruling must include instruction to perform a specific action, not generally that such and such is permitted. Some say there is a version of this Amoraic dispute with the opposite opinions. Shmuel says, the judges of the court are not liable to bring an offering for an erroneous ruling until they say to those who are seeking a ruling, it is permitted for you to perform this action. Rav Dimi from Neradea says, even if the judges say to those seeking a ruling, it is permitted for you, the ruling is completed and they are liable. Why do they have to say it is permitted for you to go do this thing? They came and asked, is it permitted for me to do this thing? And they said, it is permitted, right? Why do we need the extra verbiage? Abaye said, but isn't it so that he did not learn in accordance with the opinion of Rav Dimi in a Mishnah with regard to a rebellious elder? If the Sanhedrin ruled contrary to the ruling of the elder, and the elder then returned to his city, and he nevertheless taught in the manner that he was teaching previously, we said he is exempt from punishment. But if he instructed others to act on the basis of his ruling, that was overruled by the Sanhedrin, which stands contrary to them, then he would be liable to be executed. Not just to say, I disagree with them, this is what I think the law should be, but that's it. He's not telling people to go and act according to his minority opinion. But if he says, they said this, I say this, and you can rely on me to go do what I'm telling you, then he's a rebellious elder and subject to the death penalty. Some say there is a version of this... Wait a minute. Right. So Rabbi Abba said, but isn't it so that we did not learn in accordance with the opinion of Rav Dimi in a Mishnah, if the court instructed a woman to marry on the basis of inaccurate testimony, but she proceeded and disgraced herself and engaged in promiscuous intercourse, she is liable to bring an offering as they permitted her only to marry, and her conduct lacked the approval of the court. And Ravina said, but isn't it so that we did not learn in accordance with the opinion of Rav Dimi in the Mishnah, if a court unwittingly issued a ruling permitting the Jewish people to violate one of all the mitzvahs that are stated in the Torah, and nothing more need be said. Back to our Mishnah. The Mishnah teaches, and the individual proceeded and performed that transgression unwittingly, because he thought he was doing the right thing, on the basis of the court's ruling. So the Gemara asks, and let us teach only and perform that transgression on the basis of the court's ruling. Why do I need to add unwittingly? Obviously it was unwitting, as he thought his action was permitted. So Rava said the term unwittingly serves to include a case where the court issued a ruling that it is permitted to eat a food that is actually prohibited. So they're going to use the example of a forbidden fat, a part of the animal that is not kosher to eat. And the forbidden fat became confused for him with permitted fat. And he ate it under the impression that he was eating permitted fat. In this case, he is exempt. Then, when the Mishnah says, on the basis of the court's ruling, it means that he ate forbidden fat actually on the basis of the court's ruling. So, what we're going to be doing here, and there's a lot of nuance, and that's why this is so tricky, it's, a lot of it has to do with the intentionality and what was really going on in the mindset of the person. Normally, an unwitting transgression would be like, that you are not permitted to, light a cigarette on Shabbos, right? You know that. And so if you go ahead and light a cigarette on Shabbos, so that's an intentional transgression. But what if you got confused with the calendar and you thought it was Sunday? So you knew what the law was, but you didn't think you were breaking it because you made a mistake with respect to the calendar. That would be an unwitting transgression. And so, if the temple were standing, you could bring a sin offering to atone for it. Or, perhaps somehow you got confused and you thought, actually, you can light cigarettes on Shabbos, so you knew it was Shabbos, but you thought it was permitted to light a cigarette on Shabbos, and you did that. Okay, maybe you should have known better, but if it was genuine that you thought it was permitted, that would be an unwitting transgression. Now we're going to get into tougher, even more nuanced cases where the court issued a ruling that something that is actually prohibited under Torah law is permitted. And then the question becomes, did he rely on that ruling, or would he have violated in any way? So in this case, where some prohibited fat became mixed up with permitted fat. Did he know? Now, if he didn't know that prohibited fat was mixed in with the permitted foods that he was eating, that would be another unwitting transgression. He ended up eating something that's not kosher, but he didn't know that he was eating it. That would be an unwitting transgression. Or maybe it's that, well, this food got mixed into it, and then he said, oh, maybe I can't eat the mixture, but then someone tells him, oh, but the court issued a ruling that that is actually not prohibited, and then he eats it. Sounds like now it's an unwitting reliance on an erroneous ruling, right? These are the different kinds of cases, and there's more, but let's read. Okay, and some say that Rava said a different interpretation of the Mishnah. It is specifically in a case where the individual proceeded and performed the transgression unwittingly on the basis of the court's ruling that he exempt, right? He said, I think this is prohibited, but, okay, I heard the judges say it's permitted. They were wrong, but he relied on the court ruling. Okay, so he's exempt. And that would be an unwitting transgression because he relied on their ruling. But if the forbidden fat became confused for him with permitted fat, and he ate it under the impression that he was eating permitted fat, right? So this would have nothing to do. It's a coincidence that the court issued a ruling saying that this fat was permitted when in fact it's prohibited. He didn't know about that, right? He thought he would have, if he had known that this fat was mixed in with the food, he wouldn't have eaten it. But what happened was it got mixed up, and he didn't know that happened. So he thought he was eating kosher food. Turned out that he was eating something prohibited mixed in with it. He wasn't relying on the court's ruling. So then it becomes irrelevant that the court had issued such a ruling. Since he wasn't relying on it, it turns out that the fat was forbidden. And so it's the standard case of unwitting transgression where he didn't know that something prohibited had become mixed into what was otherwise permitted. Gemara comments, the matter that is obvious to Rava, that one who confuses between forbidden fat and permitted fat, is either exempt, according to the first version, or liable, according to the second version. And this was raised as a dilemma for Rami Bar Chama, as Rabbi Bar Chama raised a different dilemma. If a court ruled that forbidden fat is permitted, and the forbidden fat became confused for him with permitted fat, and he ate the forbidden fat, what is the law? Well, it's actually not a different dilemma. It's the same dilemma, but a different instance of it being raised. And Rava said, come in here a proof from the Mishna. The individual proceeded and performed that transgression unwittingly on the basis of the court's ruling. So why do I need the redundancy unwittingly on the basis of the court's ruling? Is the redundancy not stated to include a case where the court issued a ruling that it is permitted to eat what is actually a forbidden fat, and the forbidden fat became confused with him with permitted fat, and he ate it under the impression that he was eating permitted fat? So the Mishnah is teaching that there he's also exempt. That even though there were two unwitting things. There was forbidden fat, it was mixed in with permitted fat, and there was an erroneous court ruling that the prohibited fat was actually permitted. What did he rely on? That's not specified. The bottom line is he ate something that was prohibited, that he shouldn't have eaten, but both things are happening. That it was mixed in with permitted stuff and he didn't know, and there was an erroneous court ruling, which sounds like maybe he heard about it, maybe he didn't. Either way, according to this, he's exempt. Now, the Gemara notes, the matter was already taught in the dispute between Amoraim of earlier generations. Wait a minute. Wait, I skipped the paragraph. Some say that Rava said, come in here, proof from the Mishnah, the individual proceeded and performed that transgression unwittingly on the basis of the court's ruling. So he was aware of the court ruling. And what? Is it not in a case where one performed that transgression unwittingly on the basis of its ruling that he is exempt? But if the forbidden fat became confused for him with permitted fat and he ate the forbidden fat, not knowing about the court's ruling, then it's a standard case of unwitting transgression where he is liable to bring the sin offering. But the Gemara rejects this. Perhaps the Mishnah is saying that he is liable if he either confused forbidden fat with permitted fat and ate the forbidden fat unwittingly, or he ate the forbidden fat on the basis of the court's ruling, and either way he is exempt because there was this ruling out there. And the Gemara notes this matter was already taught in the dispute between Amoraim of earlier generations. If a court ruled that forbidden fat is permitted, and the forbidden fat became confused for him with permitted fat, and he ate the forbidden fat, Rav says he's exempt, as the court issued this ruling that it is permitted. He would have been liable, except that the court issued this ruling, even if he didn't know about it. And Rabbi Yochanan says he is liable because he did not base his own conduct on that ruling. Right? If that ruling hadn't been issued, he would be liable because he ate a mixture of prohibited fat and permitted fat. He was, let's say, negligent about that. But he didn't base his behavior on the erroneous ruling. So the fact that there's an erroneous ruling out there doesn't save him from liability to bring the sin offering for the unwitting transgression, according to Rabbi Yochanan. Now, the Gemara raises an objection to the statement of Rabbi Yochanan from a Baraisa that teaches, the verse states, and if one soul from among the common people shall sin unwittingly in performing one of the mitzvahs of the Lord that are not to be done, and he is guilty, Leviticus 4:27. Now this serves to exclude an apostate. Okay, an apostate, new thing that we're talking about. What is an apostate? This is a Jew who is rejecting the commandments of the Torah. Now, there's sort of different degrees of apostasy. Is it somebody who, generally believes in God and the Torah, but refuses to follow one of the commandments and even, violates that commandment publicly, which is a desecration of God's name? Or is it somebody who just turns his back on God and Torah altogether? These are different degrees of apostasy. So let's see what happens here. This serves to exclude an apostate. When an apostate sins unwittingly, he is exempt from liability to bring a sin offering, even if he repents. Why? Because even his unwitting action is considered intentional, right? He doesn't have the opportunity. Now we start to see a little bit of the philosophy, so to speak, of the sin offering. We're talking about liability and exemption to bring the offering as if it's so much better to be exempt. Right? But it's not always so good to be exempt, because if you make a mistake, you violate one of God's laws, and then you have an opportunity to make an atonement by bringing an offering. You have a beautiful experience, right? You do this when the temple is standing. So you bring an offering, you go up to the temple in Jerusalem. It's mystical, it's holy. In the first temple era, there were 10 revealed miracles going on at the temple all the time. And once you go through that process, you can feel whole. But this person who's an apostate, who has turned his back on God, on the Torah, on the commandments that obligate him as a Jew, he gives up that opportunity to make an atonement because he is basically he never learns the laws because he's turned his back on it. So even if it was an unwitting violation, it's going to be deemed intentional because he's never trying to learn the law or figure out what his obligations and responsibilities are. Rabbi Shimon ben Yosei says, in the name of Rabbi Shimon, it is unnecessary to derive this law from that phrase, as it says in the same verse, quote, shall sin unwittingly in performing one of the mitzvahs of the Lord that are not to be done, and he is guilty, or if his sin, which he has sinned, is known to him. Now, from the words be known to him, it is inferred that only one who repents due to his awareness, i.e., he would not have sinned if he had known that the act was prohibited, Only this person brings a sacrifice for his unwitting transgression in order to achieve atonement. But one who does not repent due to his awareness that he sinned, for an example, an apostate, who would have sinned even if he had been aware that the act is prohibited, he does not bring an offering for his unwitting action. He doesn't get that opportunity. The Gemara asks, and if it is so that one who would not repent due to his awareness is exempt, isn't this person who confused forbidden fat with permitted fat considered one who will not repent due to his awareness? Even if he discovers that he ate forbidden fat, he will not regret his action, as he relies on the ruling of the court that forbidden fat is permitted. Now, this contradicts the statement of Rabbi Yochanan, who says that one is liable in that case. And Rav Papa said that Rabbi Yochanan holds, since once it becomes known to the court that it erred, the judges will retract their erroneous ruling, and this individual will also repent when he discovers that he ate forbidden fat on the basis of the court's erroneous ruling. So we characterize him as one who repents due to his awareness, and he is liable to bring an offering. I mean, he wouldn't repent if he thinks he's following what the court told him to do. But once he learns that the court made a mistake and he relied on it, he's not going to do that anymore, right? So he would repent. He wouldn't do that anymore. He's certainly not an apostate. Rava says, even though Rav says the individual is exempt and his sin is dependent on the court, Rav concedes that in a case where one confused forbidden fats with permitted fats, he does not complete a majority of the congregation. Why is this relevant? The court is liable to bring an offering only when the majority of the congregation performs a transgression based on its ruling. This individual who thought the fat was permitted is not included in the majority of the congregation, right? He made a different mistake. He didn't rely on the ruling. He just didn't realize that forbidden fat had got mixed up with permitted fat. What is the reason? It is, as the verse states, for all the people it was performed unwittingly. Numbers 15:26. And from this it is derived there is no liability unless they are all unwitting in one and the same manner. And the action of this individual is unwitting in a different manner than the rest of the congregation. New subject. The Mishnah teaches whether the judges performed the transgression and he performed it with them, or whether the judges performed the transgression and he performed it after them, or whether the judges did not perform the transgression and he performed it alone. In all these cases, the individual is exempt from bringing a sin offering. And the Gemara, because he didn't do anything wrong, right? He relied on their ruling. The Gemara asks, why did the Tana in the Mishnah, right, the rabbi of the Mishnaic period, who is formulating this Mishnah for us, why did the Tana in the Mishnah need to teach all these different cases? Granted, in the first clause of the Mishnah teaches the Mishnah, the Tana teaches the Mishnah, employing the style of not only this, but also that. I.e., not only is exempt if the judges perform the transgression with him, but he is exempt even if he performed the act after the judges, and even if he alone performed the transgression. But in the latter clause of the Mishnah, where the Tana is teaching liability, the Tana should have taught the opposite. He should have started with the case where a person is most likely to be liable, the case where the judges performed no transgression and he sinned alone, and then go on to say that not only that, but he's also not liable, if they did it with him. And the Gemara answers, in the latter case, the Tana teaches the Mishnah employing the style of this, and it is unnecessary to say that. I.e., the cases are arranged with each case more obvious than the one that preceded it, right? When we have multiple examples, are we going from rulings that are obvious to less obvious, or from totally obvious, or from not so obvious to more obvious? It can go either way. What they're commenting on is it seems like that order is reversed from the first paragraph of the Mishnah to the second. But so what? That doesn't mean that we can learn out some other variation of the law from the way that the examples were ordered. Now we're on page 2b. The Mishnah teaches, and one of the judges knew that they erred. So one of the judges, so the court issued a ruling that was erroneous, and there was a minority in that court that knew it was a mistake. He was overruled, but he knew that they were making a big mistake. So one of the judges knew that they erred, or if he was a student, he is qualified to issue halakhic rulings. Right? He wasn't actually one of the judges, but he was maybe elevated to be a judge that day, or at any rate, his Torah knowledge is such that he realized they were issuing an erroneous ruling. Right? So in that case, we said he should not be relying on that erroneous ruling because he knows better. And if he does, he's going to be liable, unlike an individual who's not a judge or a Torah scholar at that level, who would be exempt. So the Gemara asks, why do I need the two cases? As a student qualified to issue halakhic rulings is the equivalent of one of the judges, why did the Tana mention both? And Rava said it was necessary to state both, as it may enter your mind to say that this statement that he is liable applies specifically to one who is learned and analytical. But that one who is learned and not analytical, no, he should not be liable to bring an offering. Therefore, the Tana cites both the case of a judge and the case of a student qualified to issue halakhic rulings to teach that even one who is learned but not analytical enough to be at the level of one of the other judges is nevertheless liable because he knew that it was an erroneous ruling and he shouldn't have relied on it. Abaye challenged this and said to Rava that the term a student qualified to issue halakhic rulings indicates that he is both learned and analytical. Rava said to Abaye, this is what I'm saying. If the Tana had taught the law from that first law with regard to one of the judges, I would say that this statement applies only to one who is both learned and analytical, but if he was learned and not analytical, no, he would not be liable. Therefore, the Tana taught the additional case of a student qualified to issue halakhic rulings, and from the extraneous case in the Mishna, one can infer that the law applies even to one who is learned but not analytical, or one who is analytical but not yet learned. Since he associates his action with himself, he is liable. One who's relying on his own authority to go and do something. I'm a little unclear. I guess they're talking about a different case there where, I don't know, maybe he said that the court permitted it for the wrong reason. It is permitted for a different reason, and therefore he relies on his own reasoning there. Then he's definitely going to be liable because he wasn't relying on the permission issued by the court. He was relying on his own permission. It arrived at a different reasoning. So he's liable. New subject. The Mishna teaches qualified to issue halakhic rulings, right, about this student who's still going to be treated like a judge. So the Gemara asks, like whom? Who is an example of one qualified to issue halakhic rulings who's not a judge? And Rava said, this is one like Shimon ben Azai or Shimon ben Zoma. Now, these are great Torah scholars and very famous ones. Shimon ben Zoma, normally referred to as Ben Zoma, he's in Pirkei Avos as the famous teaching, who is rich, one who is content with his portion, who is wise, one who learns from every person, who is strong, one who overcomes his impulse, who is honored, one who honors others. That's Ben Zoma. But Ben Zoma was not a rabbi. Now, by today's standards, he's a rabbi and he could be a chief rabbi. But in the time of the sages, even though he was operating at such a lofty level that his teachings are recorded in the Gemara and in the Mishnah, nevertheless, he was not ordained. He did not receive that level of semicha to be called a rabbi in that period. And the reason that he was not ordained is because tragically he died young. They would have ordained him. It just hadn't come about yet. So he's technically a student, but he is certainly competent to issue halakhic rulings. And the same for Shimon ben Azai, who some say was Rabbi Akiva's son-in-law, and some say he never married Akiva's daughter. Okay. So Rava said, it is one like Shimon ben Azai or Shimon ben Zoma, who, although they were among the most outstanding Torah scholars of their generation, were not ordained. And Abaye said to Rava, in a case like this, he is an intentional sinner, as a scholar of that caliber would certainly not err. If he ruled that a prohibited action is permitted, it is assumed that he acted with intent, and he is exempt from bringing an offering. Rava said to Abaye, but according to your reasoning, that which is taught in a Baraisa that cites the verse in performing one, if Leviticus 4:27, from which it is deriving that an individual who performs a transgression on his own, not relying on a court's ruling, is liable, while one who performs a transgression based on the ruling of the court is exempt. So how so? When does this apply? If the court ruled that forbidden fat is permitted and it became known to one of the judges that they erred, or if he was a student who was sitting before them and he is qualified to issue halakhic rulings, for example, Shimon ben Azai, so might one have thought that he would be exempt? And to counter this, the verse states, in performing one, from which it is derived that an individual who performs a transgression on his own is liable, while one who performs a transgression on the basis of the ruling of the court is exempt. So Rava continues, so rather the Baraisa is difficult. How can you find these circumstances where a judge or a prominent Torah scholar would be considered an unwitting sinner? I'm confused because isn't it, unwitting in the sense that he relied on a court ruling, but are they saying that everyone who's at that level that should know better can't rely on a court ruling? Well, what about the judges who make up the court? So I'm a little confused, but let's keep reading. The Gemara answers, it is in a case where the judge or the scholar knew that the action with regard to which the court issued a ruling that is permitted is in fact prohibited, but he erred with regard to the mitzvah of heeding the statements of the sages. He believed that there is a mitzvah to heed the directives of the sages even when he is certain that they are mistaken. If so, according to my understanding too, the reference is to one like Shimon ben Azai or Shimon ben Zoma. It is also a case where they erred with regard to the mitzvah of heeding the statements of the sages, and due to that error, they are liable to bring an offering, right? So the mistake they made, very interesting. Let's look at the case again. The court issued a mistaken ruling. This judge, or super high-level Torah scholar who's not actually a judge, knew that the court made a mistake. So at that point, since he knows for sure, he should not rely on that ruling and do that prohibited act. But the mistake he made is he thought that even in a case where somebody of his level is sure that they're wrong, that he therefore shouldn't rely, and he shouldn't do it, he thought that he should do it because they told him to do it, and he's going to rely on their ruling. So that's the mistake, the unwitting mistake for which he would bring a sin offering. New subject. The Mishna teaches this is the principle: one who associates his action with himself is liable. And the Gemara asks, what case that was not already mentioned in the Mishnah does this principle serve to include? And the Gemara answers, it serves to include one who disdains halakhic rulings in general, treating them with contempt and relying only on his own understanding, right? A rabbi who doesn't consult with other higher rabbis than him, he would be guilty of this. The Mishnah teaches the second part of the principle, and one who associates his action with the ruling of the court is exempt. And the Gemara explains this principle serves to include an additional case that was not yet mentioned in the Mishnah, namely, where the court issued a ruling and the judges discovered that they erred and reversed their decision. If one was unaware that the court reversed their decision and acted based on their initial ruling, he is deemed one who associates his action with the ruling of the court and is exempt. And the Gemara challenges, but the Tana teaches this halakha explicitly in the next Mishnah that we'll encounter on page 3. And consequently, there is no need for an allusion in this first Mishnah in the tractate. And the Gemara explains, yes, the Tana teaches it ambiguously in the first Mishnah, and then he'll teach it explicitly in the second Mishnah. Rav Yehuda says that Shmuel says, this law in the Mishnah, which states that an individual who performs a transgression on the basis of a ruling issued by the court is exempt from liability to bring a sin offering, is the statement of Rabbi Yehuda. Seems to be like that's the law, but it's the law according to Rabbi Yehuda. But the rabbis say, Rabbi Yehuda's in the minority here? The rabbis say, an individual who performs a transgression on the basis of the ruling of the court is liable. The Gemara asks, what is the opinion of Rabbi Yehuda to which Shmuel refers? It is as it is taught in a Baraisa. The verse states, and if one soul from among the common people shall sin unwittingly in performing one of the mitzvahs of the Lord, Leviticus 4:27. These are three exclusionary terms. The word one, unwittingly, and in performing. And one of these exclusions serves to teach that one who performs a transgression on his own is liable, while the one who performs a transgression on the basis of the ruling of the court is exempt. Right? Okay, we got that. And the Gemara asks, well, what is the opinion of the rabbis? Sounds like that's what Rabbi Yehuda said. It is as it is taught in Baraisa. Still, I say, each member of a minority of the congregation that sinned based on the ruling of a court is liable to bring an offering for his unwitting transgression, as the court does not bring a bull for an unwitting communal sin on the basis of the minority's transgression. Right? So the liability of the court to bring the bull, right, this very specific offering, a bull, that the court, the members of the court, the Sanhedrin would bring when they issue an erroneous ruling, that only happens when they issue an erroneous ruling and the majority of the people rely on it. If only a few people relied on that ruling, then even though they didn't do anything wrong, they were relying on the judges, but really it was just an unwitting transgression, like another type of unwitting transgression. Like you didn't know that prohibited fat got mixed in with permitted fat and you ate the mixture. You didn't do that on purpose, but you did eat something prohibited, and so you would be liable to bring a sin offering, which is always for unwitting transgression. So here, when it's a minority of the people who rely on the judge's ruling, they're not exempt. They only become exempt when the majority of the people rely on the judge's ruling, according to this view. So one might have thought that each member of a majority of the congregation that sinned based on the ruling of the court would be exempt from liability to bring an offering for his unwitting transgression, as the court brings a bull for an unwitting communal sin on the basis of the majority's transgression. To counter this, the verse states, with regard to a sin offering brought for an unwitting transgression from among the common people, from which it is derived that even members of the majority of the congregation and even members of the entire congregation are not exempt because of the ruling of the court. The exemption that we're talking about seems to be that unless the majority come to sin, the judges are exempt, even though they issued an erroneous ruling that a minority of the people relied on. But the people who rely on the erroneous ruling, according to this view, they sinned unwittingly, so they are liable to bring a sin offering to cleanse themselves, so to speak. The judges who issue the erroneous ruling, they are exempt from bringing the bull unless the majority of the people rely on their erroneous ruling, in which case the judges have to bring the bull. Now, if the judges relied on their own erroneous ruling and did the same thing that the people in the congregation did, they also would have to bring a sin offering for that. Right? So it's a different view of what we've said so far. Now the Gemara asks, in what circumstances did the majority of the congregation sin? If we say that the reference is to a transgression with unwitting performance of an action unrelated to a ruling of the court, which could happen, why does the Tana say, as the court brings a bull for an unwitting communal sin on the basis of the majority's transgression? Given that this is a case where a court did not issue a ruling, what action did the court perform? Since it was not on the basis of the ruling of the court, does the court bring a bull for an unwitting communal sin that was performed not on the basis of their ruling? They were just ruling out that whole, set of circumstances to say that's not what we're talking about. Obviously, we're talking about where the court issued a ruling and the people relied on it, right? Rather, the reference in the Baraisa must be to a case where the majority of the congregation performed the transgression on the basis of the ruling of the court. And if that is the case, the question arises, but when it is written with regard to a sin offering brought for an unwitting transgression from among the people, it is with regard to a transgression with unwitting performance of an action that it is written. In other words, doesn't this serve to exempt the people who relied on the ruling of the court? why would you say that they're not exempt, that they're all liable if they relied on the court ruling? So rather, is it not that this is what the Tana is saying? The Baraisa is incomplete, and it must be taught like this. Each member of a minority of the congregation that sinned with unwitting performance of an action is liable to bring an offering for his unwitting transgression, as the court does not bring a bull for an unwitting communal sin on the basis of the minority's transgression, in a case where the court issued an erroneous ruling. But a minority of the congregation that sinned unwittingly on the basis of the ruling of the court is also liable, because the bull hasn't been brought into it until the majority of the congregation sin. So it sounds like, well, if we get to the place where the majority of the congregation sin, and now the judges are liable to bring the bull, then perhaps the majority of the people who did that sin, they are exempt? Is that what's being said? The Baraisa continues. One might have thought that a majority of the congregation that sinned with unwitting performance of an action would be exempt, as the court brings a bull for an unwitting communal sin on the basis of the majority's transgression, in a case where the court issued an erroneous ruling. Therefore, the verse states, from among the common people, from which it is derived that even members of the majority of the congregation are liable. Yeah, they relied on an erroneous ruling, but they ended up doing something prohibited, so they are still liable to bring an offering. Now, this does seem to contradict what it said expressly in our Mishna, so let's see where we're headed. If the unwitting transgression was performed not on the basis of the ruling of the court, then there is no difference between a minority and a majority. Has nothing to do with an erroneous ruling. Then they just did something unwittingly and they have to bring a sin offering. And this is proof that according to the rabbis who disagree with Rabbi Yehuda, both an individual and a minority of the congregation who performed the transgression on the basis of the ruling of the court are liable. Rav Papa said, from where do you draw this conclusion? Perhaps in the case where a minority of the congregation performs a transgression on the basis of the ruling of the court, neither do those individuals bring an offering, because they associated their action with the ruling of the court, nor does the court bring an offering, because it was only a minority of the congregation that performed the transgression on the basis of the ruling of the court. But the Gemara rejects this view and says, if so, why does the Tana specifically seek a source with regard to the majority for liability? Why did the Tana seek to introduce the law that even if a majority of the congregation sinned, they would be liable to bring an offering? Can one not, by inference, conclude with regard to a minority that acts on the basis of the ruling of the court that he holds that they are liable, even though they acted on the basis of the court's ruling? According to Rav Papa's opinion, let the Tana first seek to cite proof about a minority that each of the members is liable to bring a sin offering for unwitting performance of an action, and ultimately seek to cite proof about a majority to establish liability for each of its members, majority of the congregation, to bring a sin offering for unwitting performance of an action, as it has not yet been established with regard to a minority that each of its members is liable to bring a sin offering for unwitting performance of an action when they relied on a court ruling. I'm almost done. Questions or comments, please get them in now. So, rather, one cannot make an inference from the fact, come on, load. Rather, one cannot make an inference from the fact that the Tana did not first seek to cite proof about a minority that each of its members is liable to bring a sin offering for an unwitting performance of an action, and then seek to cite proof about a majority to establish liability for each of its members to bring a sin offering for unwitting performance of an action. We can't, the fact that they wanted to make a proof about the minority, the majority first, doesn't teach us any kind of a law we can rely on. Accordingly, one can conclude from it that it was clear to the Tana of our Mishnah that in a case of a minority that acts on the basis of the ruling of the court, each member of the minority is liable to bring a female lamb or a female goat as a sin offering, and for unwitting performance of an action not on the basis of the ruling of the court, each member of the minority is similarly liable. And the Gemara asks, well, now that we learned both of the Baraisas unattributed, from where may it be ascertained that the Tana... that's what's going on. we're not talking about our Mishnah. We're talking about these other Baraisas that seem to contradict our Mishnah. Baraisa, these are teachings that were developed contemporaneous with the Mishnah, but were not considered authoritative enough to be included in the Mishnahs when Rebbe redacted the Mishnah. Okay. Rather, the Gemara asks, now we learn both of the Baraisas unattributed. From where may it be ascertained that the Tana of the first Baraisa is Rabbi Yehuda, and the Tana of the latter Baraisa is the rabbis who disagree with Rabbi Yehuda? You should say the opposite. The Gemara answers, whom did you hear that interprets exclusionary terms in this way? It is Rabbi Yehuda. As it is taught in Baraisa that Rabbi Yehuda says, this is the law of the burnt offering. It is that which goes up on the pyre on the altar, in Leviticus 6:2. And these are three exclusionary terms. This, the burnt offering, and it is. These terms serve to exclude what? They serve to exclude three offerings concerning which the law is that even if they are placed on the altar, they are subsequently removed. Right? Normally, if an offering that was otherwise disqualified gets put onto the pyre on the altar when the temple is standing, we don't pull it off the fire. At that point, it's too late. But there are three types of offerings that if you realize they're on the pyre, on the altar, and that they're disqualified with a heavy disqualification, you even reach in and pull them out of the fire. What are they? A burnt offering that was slaughtered at night, a burnt offering whose blood was spilled before it was sprinkled, and a burnt offering whose blood was taken outside the courtyard. So apparently it is Rabbi Yehuda who interprets multiple exclusionary terms. And if you wish, say that proof for the attribution of the Baraisas may be cited from the second Baraisa, which begins with the phrase, still I say. You cannot interpret that Baraisa in accordance with the opinion of Rabbi Yehuda. As the Baraisa teaches, one might have thought that each member of a majority of the congregation that sinned, based on the ruling of a court, is exempt from liability to bring an offering for his unwitting transgression, as the court brings a bull for an unwitting communal sin on the basis of their transgression. And if this Baraisa is in accordance with the opinion of Rabbi Yehuda, didn't he say it is the congregation that brings the bull as an offering and not the court? As we learned in a Mishnah on page 5 of this tractate, that Rabbi Yehuda says 7 tribes that sinned bring 7 bulls. The tribes bring the offerings, not the court that they relied on. That's where we will stop. And we will pick it up, God willing, on Friday. I'm going to take some questions now, but our next class is not tomorrow, because God willing, I'll be in Dallas for a special screening of Guns N' Moses in Dallas. But I fly back really early Friday morning, so God willing, I'll be back in time for our regular Friday class, noon Pacific. Okay. Joseph. I've been waiting all these years to come to this tractate. A debate with a friend well-versed in Talmud brought me to Daf Yomi concerning this topic. Does this issue about the judges include sages as well or just judges? Very good question. Very good question. Are we talking about somebody who relies on a ruling from his Rav, from his personal rabbi? Are we talking about the sages who kind of issued rulings in Israel that we follow the law? Or are we only talking about a duly constituted Sanhedrin? And it's the Sanhedrin that leads the people into this erroneous ruling? Stay tuned. Bill, okay, I'm lost. I feel that way too. But Bill is more specific. Okay, I'm lost as to how this intersects with the law of a rebellious elder. So let's say the case is this. A minority on the court, or for the sake of argument, let's say a single judge, knows the rest of the court is issuing an erroneous ruling, but is overruled. Now, he is obliged to abide by the ruling of the court under the rules around rebellious elders, is he not? Or is he allowed to say, for my part, I will personally hold by my ruling, but others should follow the court? But then hasn't he told people to follow an erroneous ruling? He seems caught in a catch-22. Good. So it does seem to be a distinction. That's why suffix is so important, right? Suffix means doubt. He would seemingly be in a situation where there's a doubt, right? He's sure that they're wrong, but they've issued a ruling. So he shouldn't rely on that ruling, nor should he rely on his own ruling in the face of their majority ruling. Sounds like he needs to kind of stay away from that action, if at all possible. Maybe that's not possible. Right? Maybe he's going to be in a situation where, like, they're saying that this is permitted, he's saying it's prohibited. Okay, he doesn't have to eat it. Right? There's no reason why he has to go eat it. Or they saying it's prohibited, he's saying it's permitted. Okay, well, even though it's permitted according to his view and he's right, he doesn't need to go eat that, right? He's not obligated to eat. So it sounds like because there's prohibited, permitted, and obligated, right? And we've only really been talking about distinctions between permitted and prohibited, not obligated. So maybe what was expected of him is to, abstain from relying either on his ruling or on theirs. Then he can teach his view that they're wrong, but as long as he's not telling people to rely on his ruling to violate what the majority are saying, then he doesn't risk becoming a rebellious elder. That's the way I see it. Sharon, how do we square the minority but correct judge's opinion and shouldn't follow that ruling with the oven of Achnai? Because the oven of Achnai, he was sure that he was right. And, right, this long story, Rabbi Eliezer said that this oven is permitted because it's not really an earthenware oven. It's made of rings. It's not a whole earthenware container that if a sheretz, a dead creeping thing, falls into it would be, disqualified and no longer kosher because it was constructed in a different way. He would say that it's not made impure in that situation. The majority overruled him, right? Now, in that case, the only reason that we know, that he was right and they were wrong is because this divine voice came and said that he's right. But, as God ultimately agreed, that was not a situation where they came to their senses later and changed the law to square with what he had been saying. The majority ruled, and the majority became the law. Right? So that's not a case where he was right and they were wrong and it was proven later. It's a case where it was a situation where the law is dictated according to the majority, and we didn't learn later, that the majority repented its view. They had the right to issue that majority ruling, and they did so, right? And because he wouldn't abide by it, they excommunicated him. Now, I don't know that he taught people to violate the majority ruling. He just said they're wrong. That's why he's not a rebellious elder, because he didn't instruct people to violate the majority ruling. That's the way I understand it. And finally, Lucy, but does the scholar not have to agree with the majority even if he is sure he is right and the court is wrong? Yes, and I think that's just what we've been saying, right? He can feel that he's wrong, that they are wrong. He can even teach that they are wrong, but he must abide by their ruling. Now, if he knows that it's wrong, he doesn't have to make use of that ruling. But he can't, right? He doesn't have to make use of the ruling. Again, the difference between permitted and obligated, right? That's what I've got for us today. And with God's help, we'll be together again Friday, the regular Friday time, noon Pacific. All the best.